Honorable Senators, I first want to thank Senator Pate for helping me draft this bill and for her support throughout its stages. Her assistance has been invaluable to me, and I thank her for it. I want to read the summary of the bill, Honorable Senators. The enactment amends the Citizenship Act to provide citizenship for certain persons when they transition out of care of a child welfare agency or foster parent. It also amends the Immigration and Refugee Protection Act to provide that in certain circumstances, a removal order cannot be enforced against a person who was not a citizen when they transitioned out of such care. At the core of this bill aims to address the issue of minors coming to Canada, being taken into government care and never becoming citizens because the government, their parent, failed to secure citizenship for them. As these children are taken away from their parents by a government, the government becomes their parent. However, the government consistently fails to carry out the responsibility of a parent when it comes to applying for citizenship. In fact, as things are, the government never applies for its children to obtain Canadian citizenship when they're under its care. Consequently, on attaining the age of 18, as these children are released from the Canadian foster care system, they face the risk of getting deported if they get into trouble. And many are sent back to the country of their parents, a country they have no connection with and of which they often don't speak the language. This is, Honourable Senators, a complete failure on the part of the government in its role as a parent to these minors. The bill will ensure that after living in Canada for a minimum of 1 year, a minor under foster care will be granted citizenship. In addition, it would prevent and/or blunt the unwarranted and unnecessary use of removal orders on adults who came to Canada as minors, but did not ever become a Canadian citizen because of the fault of our government, which acts as their parent. This bill will enshrine that all young people who come to Canada would obtain their Canadian citizenship and their rights are respected if they are taken into care. Currently, the Canadian government is failing some of the most vulnerable people. The Canadian government is failing the children who have come to Canada with the hope for the future. In 2007, the Canadian Child Welfare Research Portal's own review of provincial annual reports concluded that on any given day, over 65,000 Canadian children are in care. As these numbers date from 15 years ago, we can only imagine how they have increased since. And with that increase, so do more of our for our non-Canadian children's citizens raised by the government being deported back to the country of their parents, one that is not even that is unknown to them. Of the countless stories of the anonymous victims of our foster care system, many of which have ended with deportation, let me share with you 3 cases that highlight the darkness and pain endured by those lives whose lives are this reality. Back in 2017, during Senate's debates on Bill C-6, an act to amend the Citizenship Act and make consequential amendments to another act, Fliss Craman's case was cited as an example of why there is an urgent need to protect children who are in Canadian care without citizenship. That was in 2017, Honourable Senators, and the need has only grown since. As a side note, we owe a lot of gratitude to Senator O's work on Bill C-6. Thanks to the work of Senator O, the Senate successfully amended the bill to add the clarification that non-parental guardians can apply for a child's citizenship and that older children can apply for their own citizenship. These improvements were an important step forward, but unfortunately, they were not enough. Even with these improvements as it stands, Bill C-6 is not enough to ensure the protection of these children. Fliss Graham is one of the cases which exemplifies why. Fliss Graham came to Canada at 8 years old and became a Crown ward at age 11. She had mental health issues, as well as history of suffering from violence and sexual abuse throughout her childhood in Canada. When she committed an offense at the age of 33, Ms. Graham, a mother of 4 and a professional chef, found out that she had never become a Canadian citizen. Following her release from the Nova Institution for Women in Truro, Nova Scotia, Ms. Graham was taken into custody by the Canadian border agencies. While in their custody, Ms. Graham became very ill and had to be hospitalized due to a perforated bowel. While at the hospital, Ms. Graham was shackled to her bed, and in full shackles, Ms. Graham had a hearing where she was told she was subject to removal from Canada. Imagine, senators, this young woman came to Canada from the United Kingdom, spent her childhood in care, and then as an adult with children and a steady job, she got into some trouble and found herself shackled to a hospital bed, being told she would have to leave the country that for her was home. She did not know the home of her parents. In this instance, due to the national attention to her case and the work of the Elizabeth Fry Society, then federal government immigration minister John McCallum stepped in to prevent Ms. Graham's deportation on compassionate grounds. Had Minister McCallum not stepped in, Ms. Graham would have had to go to the United Kingdom right away, leaving her 4 children and a good career behind her. Ms. Graham's case illustrated why the amendments to Bill C-6 are not sufficient, because simply allowing a child in care to apply for citizenship on their own becomes moot if the child does not know they lack citizenship in the first place. For too many, like Ms. Fliss Graham, they do not know that they are not a Canadian citizen until it's too late. Another case which mirrors Ms. Graham's is that of Kivani Jones. Mr. Jones was born in Jamaica. At 10 years, he arrived in Canada with his parents. After less than a year of his arrival, then age 11, Mr. Jones was taken into care by Toronto's Children Aid Society, and not long after made a permanent Crown ward. That is, the government became his family. This means that Mr. Jones was a known citizen who was removed from his family and placed into the care of the Ontario government. And the Ontario government, in effect, became his family. During the entire time of being under the care of the Ontario government, he did not receive access to any of his personal documentation. Only when he was 21 did the Ontario Department of Child Services return some of his documentation. When he received these documents, he discovered that his Jamaican birth certificate had no longer been considered valid in his birth country, and his Canadian permanent resident card was near expiration. Until then, Mr. Jones believed he was a Canadian citizen. Mr. Jones was beyond shocked when he heard this. In Mr. Jones' words, and I quote, "I kind of felt disowned. I felt confused. I couldn't understand what happened." Close quotations. Jones said in an interview with The Star, talking about the confusion over his status in Canada after he was no longer a Crown ward. And Mr. Jones rightfully questioned this and stated, and I quote, "Why the Crown had decided they're going to be my parents, and all the circumstances around that would mean I'm adopted as a Canadian, but that's not the reality of it." Close quotations. For far too many, this is their reality. They come to Canada as children with their families. They are taken into foster care, and they feel they are abandoned upon reaching majority. Non-Canadian citizens raised as Crown wards face the risk of deportation to a country they do not even know. are denied any benefits which come from being a Canadian citizen, and are denied their democratic and charter rights, lose critical educational and employment opportunities, and suffer unimaginable losses of their identities, their communities, and their sense of belonging. Honorable Senators, numerous more cases have exposed the blatant injustices in the immigration system that led to individuals unfairly being at risk of deportation. Consequently, in Ontario, a multi-million-dollar class action lawsuit is being launched against the province for failing to obtain citizenship for non-citizen Crown wards. The representative plaintiff is the case of Kivani Jones. According to the statement of claim filed in the Superior Courts, the lawsuit will argue that the government has failed its duties, and I quote, to take all reasonable steps to maintain permanent residency status and pursue and obtain Canadian citizenship for the non-citizen Crown wards in its care. Close quotations. Additionally, it mentions that Canada's failure to secure their citizenship status violates their constitutional rights. Honourable Senators, no matter where they come from, when these children come to Canada, they were expecting to have a new home protected by their new country, especially when they are taken into care of the government. Then they think of themselves as Canadian citizens. Instead, following their arrival, they are taken into the care of the government. They were not Canadian citizens, but they are Canada's responsibility. Canada became the children's parent when they took them in care. As you all know, being a parent comes with many responsibilities, and the government cannot pick and choose which rights to uphold according to its liking. On the contrary, these obligations are fundamental to our obligations under international law, under domestic law, and arguably under Canadian values. Some of you may have heard about the case of Abdul and Fatuma Abdi. Along with their two aunts, Abdul, then age 6, and Fatuma, age 8, came to Nova Scotia, Canada, as refugees in 2000, fleeing Somalia. In 2001, the siblings were taken into care by Child Services when their aunt removed them from school in response to racist bullying they were experiencing. During the course of their time with Children's Services, Abdul was moved around to different foster homes 31 times. Honorable Senators, he was moved around for 31 times. Worse yet, both Abdul and Fatuma recounted detailed accounts of horrific histories of sexual, physical, and emotional abuse while they were under the care of foster parents, including being forbidden from engaging in the traditional language or customs while in care. Eventually, as a youth, Abdul began accumulating criminal charges. When Mr. Abdi's aunt attempted to obtain citizenship for him, the service intervened on the basis that Mr. Abdi was a ward of the government, and only the government could apply to grant him citizenship. Although Children's Services should have attempted to attain Canadian citizenship for Mr. Abdi, they never did. As a young adult, Mr. Abdi accumulated more serious criminal charges and ended up in custody. This led to his facing deportation through a removal order to Somalia, a place he did not know and did not have any connections to. In both 2017 and 2018, Abdu faced deportation to Somalia after completing a prison term, but both orders were overturned by the federal government. In the ruling, it was noted that the government has a responsibility to secure Mr. Abdi's citizenship, which it had failed to do. I repeat, the court held that the government had responsibility to secure his citizenship. Ultimately, the federal government dropped the deportation proceedings. On the one hand, this case led policy change in Nova Scotia. It granted powers to social workers to apply for Canadian citizenship on children's behalf. However, honourable senators, this is not enough. In order to truly rectify this injustice, federal action is needed. It is needed now. Indeed, in 2018, Fatouma Abdi asked the Prime Minister Trudeau a question about her brother's case at a town hall meeting. The Prime Minister acknowledged that Canada's care system failed Abdul, and his situation, and I quote the Prime Minister's words, opened our eyes to something that many of us knew was ongoing in many communities, but we continue to address this. Close quotations. Honourable Senators, these are the words of our Prime Minister. Even the Prime Minister acknowledged this injustice to our children and stated that it needs to be addressed. And yet nothing has been done. Clearly, the Canadian immigration laws are unfair and unable to address this crisis to our children. Current Canadian law allows for individual government departments to decide if and when to apply for a young person in their care to be granted citizenship. Far too often, these children never become citizens. If the government does not apply for their citizenship, and many do not even know that they are not citizens until they get into trouble. The government fails them, and then they are left to pick up the pieces. We are failing our children. Honourable Senators, Bill S-235 will address this issue of minors coming to Canada, being taken into government care, and never becoming a citizen, because the government failed to secure their citizenship. Bill S-235 is the only way to meaningfully and comprehensively address this injustice. It is the only way to ensure that young people who come to Canada as immigrants and refugees are fairly protected and represented in our country, while simultaneously ensuring that the most basic rights are upheld. In closing, let me remind you that the courts have spoken on this issue. The Prime Minister has spoken on this issue, calling on the Minister to act. The federal government twice in Mr. Abdi's case stated the government had a responsibility to secure Mr. Abdi's citizenship, which it failed to do. On top of that, in Surgeon's case, the judges determined if public authorities fail to take reasonable steps to secure his citizenship over a period of years, a valid concern about the appropriateness of deportation does arise. Bill S-235 answers to those concerns. I encourage you all to think of all the children who are falling through the cracks. Honourable Senators, we have an opportunity to right this wrong to our children. So I respectfully ask that you support this bill. Thank you, Senators.
Senator Simons?
Yes, would the Senator take a question? Yes. I wanted to ask Senator Jaffer, one of the challenges, and you and I have discussed this, is that it's provincial governments that are responsible for acting as the guardians of these children. It's provincial governments that are often the ones who are failing to apply for citizenship. So, understanding that we, of course, can't tell provinces what to do, what do you hope your bill will accomplish to encourage provincial governments to actually make these applications in the first place?
Senator Jaffer.
Thank you very much, Senator Simons. This is something that I have struggled with a lot, because it's true. We all know that it's the provinces that take the children into care. But our wonderful federal system, immigration law is under the federal government. And it's something really, I believe, it's our responsibility. And so the immigration law can only be changed by the federal government or by us, the Parliament. And so it is the beauty of our federal system that the federal law, if the federal law changes and becomes law of the country, the provincial social workers would have to apply to get citizenship. I know I have struggled a lot with this, but that's the only way to do it, and the courts have held that as well, because the provinces don't form immigration laws.